Good morning to everyone. Thanks for joining us today. Good morning to everyone. My name is Gail Grant, and I am a labor officer attached to the Industrial Relations section of the Labor Department. On behalf of the Chief Labor Officer and the staff of the Labor Department, I would like to welcome you to today's webinar. And this webinar focuses on the Employment Sexual Harassment Prevention Act. To those of you who would have joined us previously, I would like to say welcome back. With me today are my colleagues, Labor Officers Caroline Welch and Heather Holder. And they will assist you in answering any of your questions. Now you may post your questions in the question and answer tab. It's marked Q&A, and that is located at the bottom of your screen. At the end of the presentation, I will also open the floor to any of your questions. But before I begin my presentation, I would just ask you to join me in watching this very short clip.
The Employment Sexual Harassment Prevention Act aims to provide a framework for reporting sexual harassment cases by employees. You don't have to be physically at work during your regular working hours. As long as you are performing your duties, the rules of the Act apply. You can also report any sexual advances from clients or service providers visiting your place of work. Remember, sexual harassment may be summed up as any sexually suggestive conduct of an offensive nature in circumstances where a reasonable person would consider the conduct to be offensive. Learn more about the investigation process. Find the Act on our website at www.gisbarbados.gov.bb. Click on Resources, then Downloads.
So the Employment Sexual Harassment Prevention Act. At the end of this presentation, our hope is that it will stimulate the participants to improve their knowledge of both their rights and responsibilities. Also to encourage best practice at work and promote problem-solving approach to workplace issues, especially those of sexual harassment within the workplace. Now, the Employment Sexual Harassment Prevention Act was proclaimed law in December 2017. And we are one of the first coming out of the Caribbean to have proclaimed it law. And this law seeks to protect all employees, whether you are of the public service or the private sector, all employees from sexual harassment within their workplace. And it is only aimed at the workplace. So these laws were made to protect those persons who are most vulnerable. In the past, persons may have accepted certain things because there was no protection, but each employer has a duty of care when it comes to their employees, and they must uphold the legislation. So before I get into the legislation too deep, I will start with some definitions. The first one to note is workplace. So where is a workplace? Of course, the workplace is where you would normally go to work, but it doesn't end there. The workplace is seen as any location or place where place where a person works. So once you are there to conduct the business of your employer, whether it is that you are there for training or attending a conference, whether locally or overseas, that is your workplace. And who is an employee? An employee is an individual under a contract of services. So once it is, that person is under the control of someone, and it's established that it's a contract of services. Now, whether the person, the employer, pays the NAS or not, but all employers are required to pay NAS. And if the person earns over a certain amount, then they must pay PAYE. But this is not used as a determining factor to establish if a person is an employee. Once it is established that the person is under a contract of services, whether that person is an apprentice, they're on probation, the full-time, the part-time, or they're only paid based on commission, that person is by law an employee. The complainant. The complainant is the person who is lodging the complaint or on whose behalf the complaint is lodged. So the complainant otherwise is the person who is making the claim of sexual harassment. Next, we have the respondent. The respondent is that person who the claim has been brought against. And it may include the employer. If the employer is held responsible, then the employer may also be referred to as the respondent. So these terms I'm calling, you will hear them all throughout the presentation, and I'm hoping that you're making note of them. The next is supervisor. So who is the supervisor? A supervisor is a person who, by virtue of their office, they are in a position of authority over the complainant. So it must be by virtue of their office. This position of authority has them over the person, then that person is considered the supervisor. And last, but by no means least, we have the client. So a client is a person who conducts business with the employer. So within your workplace or your business, there may be someone who comes in to service the photocopier, or for some other reason, they have to come in to conduct business with your employer within the company. Then that person is a client, and there's a certain responsibility which goes as it relates to clients. Before we go any further, let us look at what does it mean when a person says that they have been sexually harassed. So what is sexual harassment? It's the use of sexually suggestive words, comments, jokes, gestures, but not only the use of them, but the use of these words annoy, alarm, or abuse a person. Initiation of any unwelcome sexual advances, or it may be requests for sexual favor, for a promotion, or for an increase in pay, some type of sexual favor. Or it may even lead to, or claim may come from someone claiming that there was actual physical contact. The person was in their space, they touched them and they didn't like how it felt. Also asking any intrusive questions. So anything that pertains to a person's private life. Persons may ask them about sexual positions or those kind of questions. And the person may consider that to be intrusive. It has nothing to do with work, and therefore it makes them feel uncomfortable. That can be considered as sexual harassment. Of course, the transmission of any written material like pornography, if it makes the person uncomfortable, or even sexually offensive telephone calls, or any other thing that may be considered as sexually suggestive. This list is not exhaustive. Remember what I said at the beginning. sexual harassment, where the law does not cover something, then persons may tolerate it. But because now there is protection by law, you are encouraged to, if you are accustomed making a joke with somebody and you realize that they're not taking it as a joke, then you don't go any further. Remember, it's within the workplace and you try to be as professional as possible, because a single incident could give rise to a charge of sexual harassment. One single incident. And of course, all of the meanings I've given to sexual harassment so far are in circumstances where a reasonable person would consider the conduct to be offensive. Okay? So we saw throughout the definition, some words kept coming up. So you see, it is uncomfortable, unwanted, inappropriate. These words all define what sexual harassment is. Now, within our society, it is more likely that women may report cases of sexual harassment, and it is least likely that men may report cases of sexual harassment. But sexual harassment is not only from a male to a female. Sexual harassment may occur from a female to a male. It may occur from a female to a female, or even from a male to male. So it is not gender bias. It can be anyone. Anyone may be a victim of sexual harassment. And sexual harassment in the workplace has the potential to create a very unpleasant, disrespectful, and a very unfair working environment. On screen is showing you sexual harassment in the workplace and some things that happen within the job. So people might be threatened about their employment. They may be treated in a humiliating way. And as I said, these create a hostile working environment. Now, within our society, making sexual jokes is not anything that is unusual. But I will say again, persons may have tolerated it because there was no protection by law. There is no protection by law, so you must be careful. But this is not to mean that persons can't still share jokes or have a little joke in the office. No, it's not meant to do that, but you just must be mindful of what is going on. Now, every workplace in Barbados, when the law was proclaimed in December 2017, each person was to create a clearly written policy statement against sexual harassment within the workplace. And this policy must be presented to each employee. And it will contain all the terms within the Act. Persons should know who they should go to, what is the procedure within your organization. The disciplinary action should also be stated clearly, so any employee would know, based on their infraction, what is the possibility of the punishment if found guilty. Now, if you or your company does not have the policy in place, the Labor Department, we go to organizations on your request, and we do presentations to the staff to make sure that they understand what sexual harassment is. We may come and have a discussion with the staff for themselves. Sometimes we meet with the boards and management, and then we come and meet with the staff. But it is to make sure that every employee understands this policy statement, and it must be displayed at the business that this company does not tolerate sexual harassment. So if you have not put your policy in place and you would like for us to come out and have a presentation with your staff, feel free to contact us. Now, in cases where an employee is making a claim for sexual harassment. Now, what happens? What is the employee to do? So any employer or supervisor who suggests to an employee that they may get a promotion or the sexual favor is contingent upon them accepting or tolerating sexual advances, that person may make a complaint to the Chief Labor Officer. And if you have a copy of the Act, you may look at Section 12. The aggrieved employee may lodge a complaint with the Chief Labor Officer if the employer or the supervisor. Now, where it is that the employer grants an employment opportunity or some type of benefit because an employee has agreed to grant these sexual favors to either a client or the supervisor, any employee who believes that they were denied an opportunity or a benefit, they can also make a complaint to the Chief Labor Officer because they were disadvantaged because this particular person would have granted a favor to the client or supervisor and now they have been promoted or they have received an increase in pay. Remember, your performance is not based on your sexual performance. It is based on you meeting the criteria set out in your work plan, and sexual favors cannot be part of the criteria. So therefore, any employee who believes that they were disadvantaged can make a claim against the company. Now, you must note that an employer is only liable for the actions of a client or the supervisor where that arrangement was brought to the attention of the employer and the employer failed to take action. Now, when you say that the arrangement was brought to the attention of the employer, it is not only speaking, it must be in writing. But in our society, we tend not to like to write, but really, if it is not in writing, then no action has been taken. And this is not only for sexual harassment, but as it relates to even disciplinary action, then if you have failed to write, then you haven't taken any action as yet. Let me remind you, all questions should be placed within the question and answer box and not just the chat box. If you have questions, my colleagues will answer them. Please place them within the Q&A box at the bottom of your screen. So what happens if the employee brings it to the attention of the employer and they fail to take the appropriate action? It doesn't have to end there. So where an employee alleges, because it's only an allegation at this point, nothing has been proven. So where an employee alleges that they've been harassed by just another employee or by the client, that employee, who is now the complainant, may within 3 months of the date of the occurrence. So within 3 months of whenever this incident occurred, they can lodge a complaint with the employer. But the complaint, as I said earlier, it must be in writing. Now, once the employer receives the complaint, he must, if the complaint is made against another employee, the employer must inform the employee in writing of the complaint and the details of the complaint within 2 working days. The employer must. And if it is a client that the case is being, the allegation is against, then the employer must take the necessary actions that they see fit to have the matter addressed right away. And the employer must commence investigations into the complaint within 14 days of the complaint being lodged. The complaint is lodged once the employee writes to the employer. Investigations must begin within 14 days and they shall be completed without delay. And as we go further in the presentation, you will understand why it is without delay, because everything has time frames. There's a time frame in which you need to get to the chief labor officer as well. So investigations must commence within 14 days and should be completed without delay. So after the investigation is conducted and the employer finds that sexual harassment has been committed, the employer shall take whatever disciplinary action is appropriate if it is against another employee, whatever disciplinary action is appropriate in the circumstance that employer should take. And the appropriate action would go, I guess, based on what the allegation is. And if it is a client, they would take whatever necessary action to have a remedy to the situation. So if it is an employee, remember the employee would have had the policy statement, and in their statement of employment particulars or their contract, they will have what disciplinary action goes with whatever infraction it is. So once it has been committed, then disciplinary action will be taken. After the investigation is conducted and the employer finds that sexual harassment has not been committed, the employer shall then notify in writing both the complainant and the respondent. And you notify them in writing of his decision and the reason behind the decision. Now, if it is that even after this, the sexual harassment continues, then that employee may lodge a complaint directly with the chief labor officer. So the employer has conducted the investigation. It has been found that sexual harassment has taken place, but there's no ending of it. It still continues. Then that employee would have already gone through the company's process, and having not received no stop has come to the sexual harassment, then that person can write to the chief labor officer. But it is within 3 months of the date of the event. So that is why the employer has to make sure that they finish the investigation within a timely manner, because the employee has a right to lodge a complaint with the chief labor officer if they're not satisfied, but it must be within 3 months of the date of the occurrence. Or if they are agreed by the findings of the employer and somehow the employee is of the belief that the matter was not dealt with in a way which is they believe was fair, and when I say fair, I mean following a particular process, then that employee can also write to the chief labor officer, and that is within 3 months of the notification of the decision. So if an employee writes to the company to say they're making a complaint and nothing is done, they can write to the chief labor officer directly. If it is that the employer has gone through the process, but the complainant is still aggrieved by the decision of the employer, then once the decision is given from the employer, that employee can write to the chief labor officer within 3 months of the notification of the decision. And that notification from the decision would be in writing. Now, what happens if the allegation of sexual harassment is against the employer or even the CEO of this big organization? What happens? Where is the employee to go? The employee in this situation, because it may be a case where it may be a one-door shop, or it may be a big organization, the person who's the head of the board is where the allegation is against. In a situation like that, the employee can lodge the case directly with the Chief Labor Officer. Now, when I say Chief Labor Officer, let me just clarify at this point. Chief Labor Officer means the actual Chief Labor Officer or any person by virtue of their office who represents the Chief Labor Officer. So when you hear me say Chief Labor Officer, that also includes the labor officers, right? So when they say lodge a complaint, you write all correspondence to the Labor Department is addressed to the Chief Labor Officer, and it will be investigated by the officer. Now, what happens if the allegation of sexual harassment is against the Chief Labor Officer? The legislation has stated that if it is that the case is against the Chief Labor Officer, that complaint goes directly to the tribunal. So protection is also offered for those persons employed within the Labor Department to go directly to the tribunal. And when I say tribunal, this is the Employment Rights Tribunal. But the complaint must be lodged in writing within 3 months of the date of the occurrence. Now, what happens when the complaint comes to the Chief Labor Officer? There's a situation, an employee has made a complaint of sexual harassment. They are aggrieved by the situation, or they believe the company, whatever decision the company made, they're not in agreement with it, or they don't believe that the matter was dealt with correctly, given enough attention by the company, and they have sent the matter to the Chief Labor Officer. So what is the responsibility or what is the procedure with the Chief Labor Officer? Once the Chief Labor Officer receives that complaint, then we write to the complainant, to the respondent, and notify the respondent in writing that there's a complaint against them, and we also notify them of the nature of the complaint. We will start our investigations in relation to the actual complaint, and we try to have it done within 42 days. It's not always possible, and based on what happened, it may not be possible, because if you have to rely to get certain information from certain people, persons, some things are off on vacation, but we try for 42 days in the sexual harassment. And we also will endeavor by mediation to effect a resolution of the matter. And in the sexual harassment, the legislation mentions the mediation, where we will be looking for some solution to the matter and enforce a solution. We would come to state in writing what our decision is, unlike a conciliation where we do not write a decision. In sexual harassment, the decision is written by the chief. Now, the Chief Labor Officer, we cannot carry out investigations if the complainant, not the respondent, if the complainant writes and says that they want the matter discontinued, then we cannot carry out our investigations any further. And what this would also mean is once a person, a complainant, has written to say that they do not want the matters to continue, that they wish to have the investigations discontinued, we cannot come back at a later date and ask for the case to be reopened. So you must consider carefully whether you want to proceed or whether you want to have the matter discontinued. But once an employee says, the complainant says they don't wish to have it taken any further, then once they put it in writing, it will be discontinued. Also, the Chief Labor Officer, and as I said earlier, when I say Chief Labor Officer, the actual chief or any of the labor officers may decide not to carry out the investigation or may decide to discontinue the investigations. And this is done if it is found that the complaint is either trivial, frivolous, vexatious, or not brought in good faith. And these things will happen. There may be a case where a matter seems trivial. It may be a matter that could be dealt with just in-house. It may be a situation where a person believes that they were overlooked for promotion, and it may be vexatious or not brought in good faith. And we will investigate. And we are trained to do investigations. So when we investigate and given the role of a labor officer, when we do our full investigation and we find that the matter was really not brought in good faith, frivolous or vexatious, then we will produce a report stating why, right? It is not to say that the officer just says, well, we're not going any further because we find that this was a frivolous case. The officer will write a report and a copy will be given to both parties stating why they believe the matter was trivial, vexatious, frivolous, or not brought in good faith. And also, the chief labor officer may decide to discontinue a case if it is not brought within the specific period. And that is why we said from the beginning, employers must immediately start the investigation, or you must lodge the complaint within a specific time so that it is brought to the labor officer within the specified time. So you can't wait a year later after the employer makes a decision and decide, I am not pleased by what decision my employer made. So a year later, you decide to lodge the complaint. Everything is done within a time frame. As I said earlier, when the chief labor officer makes a decision, that is put in writing, and copies are sent to both the complainant and the respondent with the decision and the reason for the decision. Now, what happens if the complainant is still aggrieved by the decision of the chief labor officer? So they went through the employer, they were aggrieved, they did not agree with the decision, or it was a situation where it came directly to the chief labor officer and the complainant still is not in agreement with the decision by the chief labor officer, then within 3 months of the notification from the chief labor officer, that person may lodge a complaint with the Employment Rights Tribunal. Now, where the chief labor officer has to investigate a matter and they believe that any person who is relevant to the investigation may have relevant information, then we can have that person served and given the relevant information or asked to produce the relevant documents. I will say at this point that under the Labor Department Act and any other piece of labor legislation, the Labor Department has the right to enter any business where they believe persons are employed. Whether it is day or night, we have the authority to enter at any time. And any person who obstructs the chief labor officer in carrying out their duties, that is a breach of legislation, not only in the employment sexual harassment, but any piece of legislation. So when the Labor Department does an investigation, they, by virtue of their office, have the authority to visit at any time. We do not have to say that we are coming. And sometimes when we visit, it is not always an investigation. Sometimes we just do routine inspections. I just thought I would share that information with you. But for the employment sexual harassment, once we are investigating a matter, we will give notice in writing and serve any person who may have relevant information. Also, we may ask the company to produce any relevant documents, and that will be served in the notice as well. Any documents which are relevant to the particular case. And when a document is produced to the chief labor officer that may be relevant, the Chief Labor Officer takes possession of the document and retains the document for as long as is necessary. However, if the document is needed by another person in order to do their work, then they will be given permission to inspect the document. So it is not, when we have documents, that if the company needs anything, they will not be allowed to still have access to the document. We will still allow it, but we retain the document for as long as is needed. Now, where the complaint is lodged with the Chief Labor Officer, once the finding is made, as I said earlier, the notification of the decision is put in writing to both the complainant and the respondent. Both persons receive in writing. And this is after the investigation, after the mediation. And mediation, we bring the two parties together and we seek to see if we can bring a resolution to the matter. So after all of this has happened, the Chief Labor Officer puts in writing the decision and notifies both parties. Now, where it is found that sexual harassment was indeed committed by the respondent, what made the Chief Labor Officer, what authority does the Chief Labor Officer have? The Chief Labor Officer may direct the company to take the necessary disciplinary action as is appropriate, because there's no blanket disciplinary action. It depends on what the infraction is, what disciplinary action is taken. And I'm going to just inject this again. Tomorrow, we're dealing with disciplinary action, so you can join us for that webinar. So you look at disciplinary action, and you look at the appropriate action for the particular infraction. And in all cases, direct the employer to take the necessary action, and we state a specific time in which this action should be taken. And this is to make sure that there is compliance and that the sexual harassment comes to an end. And we may also direct the employer to submit a report to us within a specific time to notify us of the status of the matter. So once the Chief Labor Officer makes their finding, direct the employer to take the necessary action, we give them a specific time, and we ask the person to submit the report. Now, if any person, whether it's the complainant or the respondent, is aggrieved by the decision of the Chief Labor Officer, now within 30 days of the date of that decision, that person may appeal to the tribunal against the decision. So within 30 days of the decision, they may appeal directly to the Employment Rights Tribunal. I hope you're keeping note of the timelines. Now, where the chief is of the opinion that the respondent failed to comply with the directive. So the directive was given that it must take the necessary or the appropriate disciplinary action. But the respondent failed to comply with the directions given. It may be also a situation where we have tried to use mediation, but for the particular matter, it was not successful, or based on the nature of the claim, we may determine if it may be better heard by the tribunal, then we can send the matter to the tribunal. So if the respondent fails to comply, the matter will be sent to the tribunal. If we cannot get it settled, we send it to the tribunal. Or if based on the nature of the inquiry, it may best be settled by the tribunal, we can send the matter directly to the tribunal. Also, if the matter, we find that we can't get the matter settled within the 42 days, then we could endeavor to have a settlement by lodging the complaint with the Employment Rights Tribunal. And remember, the tribunal has the authority of a court. Now, what happens if the matter goes to the tribunal? I'll say tribunal, the Employment Rights Tribunal. So the tribunal conducts an inquiry into the matter referred to it. And all matters of sexual harassment are held in camera. So they are behind closed doors, they're not public. Right now, once there is a tribunal matter being heard, it is public. So anyone can come in and sit and listen to the tribunal hearing. Well, that was pre-COVID. I'm not sure what measures are in place now that it's COVID times, but the normal Employment Rights Tribunal cases are not private matters, they are public. But once it is a case of sexual harassment, that matter will be held in camera. It will be behind closed doors. Now, the tribunal shall endeavor to resolve the complaint, which has been referred to it, and they take all necessary steps to resolve the complaint. If they need to adjourn and negotiate with the parties in a view of reaching a solution, then they will do that, just as a court will. Now, if it is that the complainant writes to say that they want to have the matter discontinued, and they write to the tribunal and indicate that, then the matter, the inquiry will not be held or discontinued. Once that person writes to the tribunal indicating they don't want the matter to go any further, then it is not, it doesn't go any further, but it must be in writing. Now, what happens when the matter goes to tribunal, the hearing, there's a hearing to be set. What happens? Who attends the inquiry? The tribunal, by notice, and this notice is in writing, they would write to the complainant, the respondent, and any person who, in the opinion of the tribunal, is able to provide information relevant to the complaint. And that person will be served just like court. And they have to attend the inquiry for the purpose of resolving the matter. Now, the determination of the complaint, where the tribunal has held the inquiry, they have their findings. They have the authority to either dismiss the complaint or find in favor of the complaint that the respondent actually engaged in sexual harassment. So the power of the tribunal, they can dismiss the complaint or find in favor of the complainant. So where the finding is made, and it is found that the respondent did in fact commit sexual harassment, then the tribunal can ask the respondent to compensate the complainant in an amount that the tribunal determines. So the tribunal will say what the award is. And this award may include compensation for injury to feelings and punitive and exemplary damages, unlike a settlement for unfair dismissal, claim for sexual harassment. The compensation may include compensation for injuries to feelings and punitive and exemplary damages. And the tribunal may use precedents to determine how they award, but the award is determined by them. And they can also ask the respondent to pay the cost of the complainant. So if the complainant has legal fees, attorney fees, or their representative has to be paid, then the tribunal can order that these are paid. Now, where the tribunal finds that the complainant had been dismissed, so there's a case going on and the employer dismisses, the respondent dismisses the complainant from work because they made a claim of sexual harassment, then the tribunal can take whatever action as it sees fit. If the dismissal occurred because they made the claim of sexual harassment, the tribunal has the authority to make whatever action is fit in that situation. And this could amount to unfair dismissal, right? Remember, the tribunal has the final say and they're the authority on unfair dismissal. Now, the decision of the tribunal shall be in writing, and it will include the reasons for the decision, a statement of the findings, of the facts, reference to any evidence, and any other material. And this judgment will be served to both parties. The judgment is served to both the complainant and the respondent. And the tribunal will ensure that they are both informed. Now note that any person who fails to comply with an order by the tribunal, and remember I said the tribunal has the power of the court. So any person who fails to comply with an order by the tribunal is liable to be proceeded against and punished in a manner as if he were found guilty of contempt of court. So if the tribunal orders that you attend the hearing and you don't, then you will be liable for any action brought against you for not appearing. Remember, the tribunal has the authority of a court, okay? And in any tribunal, we think there will be three persons, the chairperson and two, one for the complainant and one for the respondent. Now, what if the person still is aggrieved by the decision of the tribunal? Any complainant or any person, whether it is the complainant or the respondent, that is aggrieved by the decision of the tribunal shall within 30 days of the notification of the decision, they can appeal against the decision. And this decision is done by a judge in chambers. It is not a public court hearing. The appeal of the tribunal is against the decision is to a judge in chambers to maintain that confidentiality. So we have questions all the time. What if I write for sexual harassment? Would I not be victimized? What if I'm called to be a witness? I may know what's going on, but I have my job. What do I do? Because I get summons by the tribunal, but I still working with this person? No, the legislation, the Employment Sexual Harassment Prevention Act, prohibits any victimization of employees. So no employer shall carry out any action against any employee because they have, one, if they have rejected your sexual advances, if they have lodged a complaint in accordance with this act, if they are asked to give testimony, because if a person is asked to give testimony, remember, if they don't show, then they're held liable. And if they have to participate in the investigation, no action should be taken against any employee for any of these reasons. The legislation strictly prohibits any victimization. No person shall be subject to any threats on the ground that they made a complaint or they furnish any information. And if it is found that the person is threatened or they face any action, then a person who contravenes these prohibitions is guilty of an offense and liable on summary conviction to a fine of $10,000 or to imprisonment for a term of 2 years or to both. So far, no one has been found guilty, but We can test the law to see. No, we wouldn't want that. We wouldn't want anyone to test the law. We know that most persons will comply. And even if at first they're not compliant, once they understand what it is the law requires, then they will become compliant. Right? Now, what happens where a person goes through this whole allegation and the respondent is found guilty, and then you find that a false complaint was made? Any person who makes a false statement of sexual harassment against another person is guilty of an offense. So you cannot make a false complaint and then expect to just get away with it. That person is guilty of an offense and liable on summary conviction to a fine of $10,000 or imprisonment for 2 years. Or it may even be both, right? So note where a complaint has been received under this act, except if the tribunal permits, no person is allowed to divulge or communicate any particulars of that complaint. So you have the investigation going on, you had a meeting, and after the meeting, somebody comes and say, wait, that is Jane case of sexual harassment. What happened in there? What she said? No. Not beginning at that point and not when it goes all the way up to the tribunal. Any matters dealing with employment sexual harassment must be dealt with discreetly. So no person, except if the tribunal permits, is to divulge or communicate any particulars of the complaint. So a person is called to be a witness, they go back to work, the employer cannot say to them, you must tell me what occurred, except if the tribunal permits them to do that. So thank you very much for joining me. I also say at this point that the legislation offers immunity to the Chief Labor Officer or any of the officers actually in respect of doing their job in good faith. So no case can be brought against the Chief Labor Officer or any of the officers who are operating in good faith, just doing their job, doing their investigation. I hope that you found this information to be useful, and I will open the floor to your questions. Just before I open the floor to your questions, I just want to go through a couple scenarios. Now, you would raise your hand if you want to answer the scenario. So here we have, you can see on screen, Mark and Shelley are work colleagues. They live in the same area. Mark gives Shelley a ride to work on mornings. One morning on their way to work, Mark tells Shelley he loves her legs and he proceeds to touch them. While at work later that day, Mark is called to the HR department and informed that a case of sexual harassment is being brought against him. Could this really be a case of sexual harassment? I want to hear from you.
Good morning.
Good morning. State your name because I can't see.
Karen Coultress.
Hi, good morning.
How are you?
I'm good. How are you today?
I'm fine, thank you. Yes, I believe that that is a case of sexual harassment. Even though he is giving her a ride and they are not in the workplace, they are on their way to work, and I think that that is very inappropriate. The inappropriate behavior.
It is inappropriate behavior. But is it sexual harassment in relation to this legislation? Is it a case that could be brought through this legislation? Think about it.
For me, I believe that. You could tell me whether I'm right or wrong.
Okay. I want to hear from somebody else before I say whether it's right or wrong. But because you have to state your name when you come into the chat. Let me hear who the person is. Let me hear one more person, Caroline, and then it will tell you. Let me hear someone else.
Hi, good morning.
Good morning.
Hi, I don't think it is inappropriate, but within the law, it states that being on work premises or in the duties, carrying out duties to at work. So if it doesn't happen on the compound or in relation to work, that would be a matter for police.
Right. So it is not the workplace, because remember at the beginning we defined the workplace, and the workplace is any place where they're conducting the business required for your job. But he's just giving her a right to work. So it is not the workplace. So I'm hoping Caroline heard that. This cannot be a case of sexual harassment, and just because it is not the workplace. We can look at another one quick. So let's look at this one. Right. Jeff sees two of his colleagues, Steve and Judy, in a room alone. Now he notices Steve holding Judy very closely and caressing her. He reports the matter to the HR manager. Steve is then summoned to the office of the HR manager. So do you think a case of sexual harassment could be brought against him? So let me see who has their hand up. Let me hear Allison, then Christina, then Janelle. So let me hear you, Allison. Allison? Not hearing. Allison? I see your hand is up, but I'm not hearing you. Or Christina? I'm not hearing.
Oh, I'm here.
Oh, it's Christina. Let me hear from you. What do you think?
Initially, I would think it would be between the two individuals in the room, but the fact that it happened on work premises, I'm not sure if then a case can be brought against them. And if that's the case, it will have to be brought against both of them and not just one, because they were involved with the act. But as an outsider that who brought the case, I'm thinking that if anything is to be addressed, it will have to be both individuals in that room and not just the gentleman.
So, and you believe it is a case where it's a breach of the sexual harassment legislation?
I will go ahead and say no, because the person that did the complaint, it wasn't against them personally. They're assuming that the young lady, the female in the room is being harassed, but they don't know.
Right. So the complaint, the person who is making a claim of sexual harassment, it must be unwelcome and uninvited. But apparently the two of them were very close and the person happened to see them.
Mm-hmm.
So it may be inappropriate workplace behavior, and it's not saying that they still cannot face some type of disciplinary action. But it may more be for inappropriate
misconduct.
behavior at work than sexual harassment. I'm going to share one more. Oops. Sorry. Let's look at this one. So Michael was touched inappropriately by his workmate, Sherry, in January. Now he was between ways because you know how our society is. He felt it was inappropriate, but he really didn't know if he should complain to his supervisor or not. And he finally decided that in March, he's going to make an official complaint in writing. So can a case of sexual harassment be brought against Sherry? Carrie Ann? Carrie Ann? I can't hear you, Carrie Ann. Or Kyle? I see your hand is up as well, Kyle.
Hi, good morning.
Hi, Kyle.
Well, based on what you said previously, as long as it fell within the 3 months period, he still has the right to formally do his written complaint. But if it has passed, 3 months have passed, no, he really does not have a case.
And that is correct. So what about the fact that it is a man and she has touched him inappropriately? That has any bearing on the case?
No, sexual harassment does not look at gender. It is the act of making the other person comfortable, be it male to male, male to female. It doesn't matter.
That is correct. Sexual harassment does not take into account if it is female to male. Once it is that it is found that the act has occurred, then it is sexual harassment. I can do one more. I said that was the last one, but I want to do this one. Thanks, Kyle. I'm going to look at this one. It's the last one. So Mary told her friend Jane that she was sexually harassed by the owner of the company. And it occurred 1 month ago, but she didn't know what to do. Jane told her that seeing she was sexually harassed by the owner and there wasn't anybody else for her to go to, that she should just let it go and hope it doesn't happen again. I need for someone to tell me, do you agree with Jane? And if not, what advice would you give to Mary? So let me see, and then we will. Okay, Christina, you have your hand up.
She can go directly to the chief labor officer, right directly to them within the 3 months. So she still has time.
Yes, that is correct. Don't mind that the business is a small business and she feels as though she doesn't have anyone else to go to in a situation like that. She can come right directly to the chief labor officer. Now at this time, I would take your questions. If you need to ask a question, just raise your hand and I will seek to answer your questions. Any questions you may have, that's all. We still have, let me look in the question and answer and see what we have. No questions at all? There's nothing you want to know or nothing you wish to discuss? Well, if that is so, I would like to thank you very much for attending our webinar this morning. Tomorrow, we will be speaking about disciplinary action and acting in accordance with the disciplinary action in accordance with the Employment Rights Act. And you are invited to join us as well. And thank you very much for joining in with us today. And we will see you tomorrow.
We can dream because there is where it all begins, with a step, knowing we can do it. See the light. It's time to realize our potential to grow, to be whatever we dream. Focus on our goals, to be the winners with science and technology. Together we can go far. Pride and industry, that's our motto. So getting qualified, we can go far. We've got skills, we can compete, develop, train, innovate. Come on, be unique.